welcome to LawSplained Simply, a channel designed for you to educate you and empower you when making litigation decisions. My name is Ruzbe Hosseini, and I'm a lawyer at Cambridge LLP in Toronto, Ontario, Canada. And I and my firm regularly assist clients when making litigation decisions. This is episode 6. And in prior episodes, if you recall or if you've watched them, we discussed how to commence a lawsuit, in what courts to commence those lawsuits in, and we even discussed in the last episode a couple examples of causes of action and how they work. In this episode, we're going to discuss the consequences of not defending if you're sued. And that's very important because there are severe consequences if you don't defend. So let's get to it now. Before we discuss what happens if you don't defend, I want to remind everybody how much time they have to defend if they're served with a lawsuit commenced in Ontario. So if you live inside Ontario, you have 20 days to defend. If you live elsewhere in Canada, or if you live in the United States, you are given 40 days to defend. If you live elsewhere in the world, so outside of Canada and the United States, the time to defend increases to 60 days. And if you don't defend, so if you fail to defend, there are consequences, and severe ones at that. The first is that the plaintiff can do what's called noting you in default. And a noting in default results in a deemed admission of the allegations of fact in the statement of claim. So if you recall, in previous episodes, we discussed how lawsuits are commenced, and that's by statement of claim. And in the last episode, we discussed causes of action, okay? Those allegations that are written into the statement of claim to form the basis of the lawsuit. If you don't defend, those allegations are deemed to be true. And as a result of being noted in default, it will result in you not being able to participate in the litigation. And so that means several things. First, it means you won't be able to defend. Second, it means that you won't be able to bring or respond to motions that are brought before the court. Third, it means that you won't be able to participate in discovery. And finally, you won't be able to participate in the trial. Now, when you are noted in default, the plaintiff can then bring what's called a default judgment against you, okay? And that means that the plaintiff can obtain judgment without your participation. And there are really two methods in which the plaintiff can do that, and that depends on the kind of damages that the plaintiff is seeking, okay? The first type of damages are called liquidated damages, and those are fixed or ascertainable sums of money that the plaintiff is claiming. If the claim is for a liquidated amount, then judgment is obtained administratively without the need for a hearing. And examples of a liquidated claim are like an unpaid debt, or an amount agreed upon between the parties in a contract that forms the basis of the claim. Unliquidated claims are claims that require assessment by the court. And examples of that are, for example, tort claims. An easy example is a slip and fall. Okay, the plaintiff slips and falls in your home and sues you as a result of being injured. That's not a fixed or certain sum of money. The damages as a result of that injury have to be assessed, and so therefore the plaintiff can't obtain default judgment over the counter or administratively. There has to be an assessment done by the court. And so a hearing is conducted before a judge or an associate justice, depending on the circumstances, to determine what those damages are. But in all circumstances, liability is conceded. Okay, and that's because if you're noted in default, the facts stated in the statement of claim are deemed to be true. Other issues could arise. For example, issues of pure law to be decided in the hearing can also be determined by the judge or the court at the hearing. But aside from issues of law and the damages to be proven, all other facts are deemed to be true. There are also cost consequences for not defending. And if default judgment is obtained, those cost consequences, in addition to the damages that are awarded, are the plaintiff is entitled to his or her legal costs for obtaining judgment, and you'll be liable in all likelihood to pay interest on that judgment. And the amount of interest will depend on what the stated amount is under the Courts of Justice Act, but also if you have an agreement on what the interest is, then that agreement will dictate. So, for example, if the claim was for an unpaid debt and you have a written agreement stating that interest was to be paid and you didn't pay that interest, let's say that interest was 10%, then it may be that you'll be liable to pay interest on that judgment at 10% if the plaintiff obtains judgment for that unpaid debt. In addition to having to pay costs, so in addition to those cost consequences that we just discussed, there are enforcement measures that the plaintiff can take against you, and those include examinations in aid of execution, writs of seizure and sale, garnishment of wages or bank accounts, and other enforcement measures that we will discuss in future episodes. Thank you very much for joining me on this episode of LawSplained Simply. Don't forget to join us once a month where we create new videos on legal topics. Don't forget to like, subscribe, and comment, and I look forward to seeing you on future episodes. Bye-bye.